And welcome to the Week 2 video lecture. In Week 2, we're going to take on some of the more important aspects of evidence, and those are the fundamental requirements for getting evidence into court. And one of those fundamental requirements is what we call relevance. We'll talk about exactly what relevance means. Certainly, it is very similar to what we think of in the normal sense of the term relevant, but it has a very specific meaning that we do have to pay attention to. We'll also look at some of the older common law rules regarding relevancy and materiality that are now defunct because the federal rules of evidence have come into being and now guide entirely in the process of introducing evidence into court. We'll also be looking at when we can admit relevant evidence, when it's admissible, which is generally all the time except for a few times when there may be times when relevant evidence needs to be excluded because perhaps it's relevant, but it's also potentially unfairly prejudicial and therefore can bring on negative consequences to the ascertainment of truth. We'll also look at some of the ways in which we will be able to take out relevant evidence based on a number of different reasons, all of which are under the Rule 403 of the Federal Rules of Evidence. That is basically a catch-all that says, under certain circumstances, even though we have relevant evidence, we're going to exclude it because there's some very important reasons for doing so. Some of those are policy reasons. Some of those are because we fear that it will be misused. It may also just waste time, and it's difficult for juries to deal with that evidence in some fashion, so that it's worse to let it in than to exclude it, and that kind of thing. So this is very important. This is fundamental to getting evidence into court. So let's get right into it and see what this is all about. All right, let's look at the old common law definition of relevancy. Again, this is not, it's no longer the definition because we've changed all that under the rules of evidence, but it was, evidence was relevant if it sheds light on some issue in the trial. It's a very broad standard. In essence, if someone's testimony about the defendant's having some odd behavior before a murder took place that was consistent with someone who was preparing for a murder, for instance, that might be relevant evidence because it can shed light on the issue, which is who did the murder in the trial. So it's very broad. We'll see that when we get into the Federal Rules of Evidence, it's a little more narrow, but it is very similar. And then they used to have also a companion concept called materiality, which really meant it has to be, of some value. I mean, some ascertainable and demonstrable value. If it's just so ridiculously small in terms of its value, then we won't let it in. Now, materiality has been displaced. We no longer have materiality as a requirement to get evidence in. And the reason for that is that we often have circumstantial evidence cases where there's many, many, many pieces of evidence, all of which are very small. But when you put them all together, they make one very large and very material bit of evidence. And so we can't let materiality be the standard that we can use, because otherwise quite a bit of good quality circumstantial evidence would be excluded. But materiality means evidence must have some potentially demonstrable effect on the case. That means that, in essence, it has to make a difference in the case. Well, any one piece of circumstantial evidence, when there's, for instance, or perhaps hundreds of pieces, would be able to be excluded because we simply don't have enough materiality to any one piece. And that's the reason why materiality was thrown out, is that it doesn't work in many contexts. It doesn't have to make a difference by itself for it to get in to evidence. These are the old requirements. Now let's look at the ones that are now to be used. Okay. By the way, evidence is immaterial under the old standard if the value of the evidence was outweighed by its prejudicial effect. But we'll see how that comes into Rule 403 when we get into that. Again, so common law is gone. It doesn't no longer there. We don't follow it. Let's go into the specifics. There's Rule 401, very, very fundamental rule. This is also exactly the same rule under the California Evidence Code. Down to the exact wordage. And it says evidence is relevant if it has any tendency to make the existence of any fact of consequence to the action more probable or less probable than it would be without the evidence. That means it has to have some ascertainable effect on the finding of a fact or the finding of the absence of a fact. If it does, then it is relevant. So that would allow us to have these very small pieces of circumstantial evidence, and when we put them all together, we get some really big, good quality evidence, but by themselves, they really don't make a difference in the case, but they do tend to make a fact more likely or less likely because they are there, and therefore we can get it in as relevant evidence. And we'll see here in a minute that all relevant evidence is admissible in a court, except under certain rules that might exclude it. And so again, no materiality requirement for evidence under the current law. It simply means if it's relevant, it comes into evidence, unless it's excluded by some other rule. That's in fact the next thing that it actually says. Under both the federal rules of evidence and California rules, this is exactly the same language. All relevant evidence is admissible unless it's excluded by some other law or evidence code section. So if you have relevant evidence, you have a pretty good chance of getting it in. In essence, if your evidence is relevant and someone objects to it being admitted into evidence, they're going to have to come up with a rule or a law that says it should not come into evidence. And if they cannot, it's coming into evidence. That's how powerful this rule is. So this is the kind of rule that I tell my students all the time. I want you to burn the mirror image of that into your forehead. So every time you look in a mirror, you're going to see this rule, because you have to start out all of your inquiries regarding evidence with this rule. First, is it relevant evidence? If it is, it's coming in unless someone can bring to our attention some rule or evidence code that excludes it. Very, very important, because that means that most relevant evidence is going to get into court. And again, it has to be a really good reason for it to be excluded. Very important. So keep that in mind at all times during our class. We'll see that coming up more and more often as we go through our lectures. All right, let's look at some of the exceptions to introducing relevant evidence. First is the Constitution. The Constitution in criminal cases, by the way, and very few of these things actually enter into civil cases because, frankly, the Constitution doesn't really protect your financial rights very much. It protects you against being unlawfully convicted of a crime or having your constitutional rights violated and the evidence from those violations being used against you in a criminal case. It doesn't protect you from that being used in a civil case because the Constitution is really not so keen on protecting people's financial rights. It is very keen on protecting their rights to freedom. And so if we find evidence that was not legally obtained under the Constitution. So let's assume that police just break into your house without a search warrant for no good reason, and they come in and they find something and they now want to prosecute you with that. That's a violation of the Fourth Amendment. No unreasonable searches and seizures. The court will exclude it, even though there's no evidence code that says it's to be excluded. The Constitution will demand it because the courts say we can't keep police from violating people's constitutional rights so long as we allow them to use evidence that they've illegally obtained in court, because if we keep letting them do that, they'll keep on violating people's constitutional rights. So the way to stop them from doing that is to take away the benefit of the illegally obtained evidence. And so we're going to get into that in chapter 12, by the way, so you'll see this one again. Also, privileges is the next area where we might be able to take what would be relevant evidence, and sometimes very, very good and very important evidence, and we'll often for public policy reasons, we will exclude it. So I'll give you the best example, of course, is your attorney-client privilege. A criminal defendant comes in, talks to his attorney, says, yeah, I did it. Everything they say about me is absolutely true. I did this horrible thing. That's a confession, and that confession would be really very important evidence if we could get it into trial. People like it when we see people confessing to things because then we don't have any doubt anymore but that they're guilty. And we feel good about a verdict of guilty under those circumstances. But we're not going to allow that into evidence because we have to protect another interest that's very, very important to the ascertainment of truth, and that is the ability for the defendant to be honest with their attorney about everything so that the attorney can defend them as best they can under the circumstances. If the attorney doesn't know something, because the client's not telling it to them, and it's not telling it to them because they think it's going to be used against them, then they will not have proper legal representation. If they don't have proper legal representation, then we feel like we're sort of railroading people into verdicts of guilty and in criminal cases when that's the last thing that we want to do. All right. Also, unduly prejudicial evidence. That means this is actually under Rule 403. We'll look at that in a minute. But sometimes evidence is relevant, but it is so incredibly prejudicial. Let's assume that we have a person who is had let's say 3 or 4 burglary prosecutions against them when they were somewhere between 18 and 21. They were kind of on drugs during that period of their lives, and they cleaned up. They got a good job. They've been a model citizen for 40 years, and now they're in their 60s. And they have a case where someone ran into them in a car, and they want to get compensation for the losses that they suffered as a result of someone's negligence. Well, then what happens is, it'd be nice, if we could, if we were defense in that case, come up and say, well, isn't it true that you had all these burglary convictions when you were 18 to 21 years old? These are felony convictions of theft crimes, showing a dishonesty, and so you're just a bad guy. And by the way, when we get in evidence that says you're a bad guy in any way, or even suggests it, juries take that, unfortunately, very seriously and use it for the wrong purpose. It's often been said that when we go into jury trials, the jury's really looking for who has the black hat and who has the white hat, who's the good guy and who's the bad guy. If you're a good guy, they're gonna disregard lots of evidence that they shouldn't, in terms of giving you a break. If you're a bad guy, they will hurt you no matter what, and even if the evidence isn't that good, they'll come after you. And this is, by the way, responsible very much for the celebrity effect we've seen, where a lot of celebrities are getting off of crimes that we know that if someone who was not a celebrity had the same evidence being used against them, they would have been convicted without any problem. But because they're celebrities, they are considered to be the white hat, and they get a break. That's how juries deal with the evidence. So it can work both ways. We can have stuff that makes you look like a saint, and it makes you look like the white hat. And that's overly prejudicial also, even if it's not prejudicial against you, it's prejudicial against the other side. Or it can be stuff that you have done in your past that really has no relationship to who you are now, and has no relationship to the believability of the evidence that's put before the jury, but they will bring it up anyway in order to paint you as the person with the black hat. And that's sort of what unduly prejudicial evidence is. It's stuff that is, I call it sliming evidence. We try to slime the other side with evidence. Or perhaps we try to make our own client into a saint somehow. Either way, it works one way or the other. It's trying to paint either our client with a white hat or the other side with a black hat, so the jury will be prejudiced against them and not want to go their way, even if the evidence says that they should. All right. Also, sometimes evidence is just overly time-consuming. That means that it's going to use up too much time. And I'll give you a good example of this. Let's assume that you have someone who comes in and testifies to their good character, their character for honesty. And this is in a criminal case where they're prosecuted for embezzlement, which is a crime of dishonesty and theft. Well, they would want to come in and bring up their reputation. I have the best reputation in the world for being the most honest person that's ever walked the face of the earth, that kind of thing. And so you bring on all these people who who say, oh yeah, I've dealt with this person for the last 20 years and they've been completely honest in everything they've ever done with me, and they have a reputation for being honest in the community. I think they're be extremely unusual to even assume that he would ever commit any kind of embezzlement. Well, then I want to cross-examine that person if I'm the prosecutor. I want to say, okay, well, it's interesting you say that, but if you knew that he had committed these 12 acts of embezzlement, would that change your opinion? And then they might say, well, yes. Okay, well now the problem is, are we going to allow you all the time necessary to prove up 12 cases of embezzlement, perhaps that had never been prosecuted? We know they happened, or at least there's good evidence that they happened, but are we going to have 12 mini trials just to give you the opportunity to put on a little bit of evidence suggesting the person doesn't have a very good reputation? Ooh, that's a tough one, because trial time is very, very expensive. Last time I remember, way back in the 90s, It was something like $10,000 a day is what it costs to run a court. And they're not just going to give you, 3 or 4 or 5 weeks to prove up 12 cases of embezzlement, especially when there was been no convictions. So we got to prove the whole case over again, and do all that and bring up all that old stuff just to prove a little bit of evidence on reputation. It's overly time consuming. So you know what, you gotta use the court system in an economical way. You can't just prove up the whole world, make it into a basically 3-ring circus about the parties. Can't do that. So we will not allow that kind of evidence to come on because it's just too time consuming. Or perhaps let's assume that we have a case in California now, when we have a sexual assault case, prosecution now can bring up even uncharged sexual assaults that have happened with that same defendant as evidence, proving that they did the sexual assault involved in the current crime. And so let's assume we have 25, 30 women who come in and say, yeah, this guy raped me, and so on and so forth. The judge might say, okay, you know what, I'll give you 5 of them. I'm not going to give you 30. After 5, the jury's not going to care whether you have any more because they're sort of already assuming this guy is a rapist. So why would you have me have 25 more of them come in here and use up another 2 or 3 weeks of our time examining and cross-examining those witnesses? We're not going to do it. All right, also rules of civil procedure. Sometimes in civil cases, courts can exclude evidence for other policy reasons, such as, and we'll get this in Chapter 8, settlement negotiations. We want people to settle cases because we don't have enough courts to try every case, not even close. We only try about 1 or 2% of the actual cases that are filed. And if it weren't for that, if it wasn't for the settlements that do go on before the trial happens, the whole system would fall on its face because there's just not enough courts to try things. So we want to encourage people to settle things outside after they've looked at the case and see, of course, who's the one that should win, and they know what the strengths and weaknesses of their cases are. We want them to settle. Okay. Well, if you allow settlement negotiations to be used against a party later on in a trial, then you're not going to get real, honest discussions about the case. And even if someone offers to settle the case at something less than perhaps they should get, they could be used against him at the trial later on, saying, "Oh, he offered half that much to settle the case, so obviously half as much is really all he's entitled to." You don't need that kind of stuff going on. And so, if you had that stuff going on, if you did, you'd say, "You know what? I'm not going to be involved in settlement negotiations because it's going to be used against me later on." So there's a rule right there. Is that we say, "Okay, we're not going to allow whatever you say, no matter what, to be used against you if it was in settlement negotiations for policy reasons, because we want you to settle, and so we'll give you that privilege, so to speak." All right, so let's look at unduly prejudicial evidence under Federal Rule of Evidence 403 and California Rule 352. That's Evidence Code 352 of the California Evidence Code. All right, it says relevant evidence may, which means that it's discretionary with the judge because it doesn't require them to exclude it, but allows the judge to actually be the one to decide whether it will be excluded. It will be excluded if its probative value is substantially outweighed by one of several things. Okay. We first have to have relevant evidence, and then someone has to bring up one of these several ways in which the evidence might be, in some fashion, have negative consequences on the trial. And then the court then has to decide, okay, how important is this evidence? How much probative value to the case is it? If it's very, very important to one of the sides to a case, it's in fact without that they can't even make their case, then it has very, very high probative value. If, on the other hand, the person's case has been so well proved over and over and over and over again, and so this one little extra piece doesn't mean very much, then its probative value is actually much less, in fact, very, very low. But what happens is the court has to both look at the probative value, that means the value to the case of the person who wants that evidence, versus the negative consequences that can come from using that evidence in the trial. And once the judge has both of those things in his hands, in his or her hands, and is now weighing them, the probative value must be substantially outweighed. That means that the prejudicial effect must be much higher meaning much higher. It's just not just a little bit higher, but much higher. So if they're really one and the same, meaning the probative value is about the same as the negative consequences, that evidence is going to come in over this rule, because the rule says it has to be substantially outweighed. That means you put it on the scale, and the scale just tips them right to the opposite side. I mean, the negative consequences are so heavy, they throw the scale right off to one side or the other. Okay, so when we're looking at negative consequences, what are the things that will be weighed against public or probative value? Number one is danger of unfair prejudice. This is what I call the sliming evidence, which I talked about before. You can slime somebody with all sorts of stuff. You can slime them with some of their social media posts where they said, "Oh, I think people shouldn't be so hard on these child molesters," or something. You say something stupid like that on your social media, and they pick up on that. They're going to be bringing that in. Isn't it true, sir, that you think it's okay for child molesters to be out there molesting children? And you say, "Well, no, of course not." Well, wait a minute. Didn't you say on social media that you thought we shouldn't be so hard on them? And that gets into the jury. Oh my goodness, they're going to say, who are you? And you are a bad person. We don't like you, and we're certainly not going to do anything good for you because you're a bad person. You're a black hat. So you can see if we get that evidence in, it may have very small probative value, but boy, it sure is going to be prejudicial to the side who gets that kind of stuff. That really has nothing to do with the fact there was a breach of contract. For instance, here, the person paid this person some money and wanted whatever they were supposed to buy, and the person never delivered it. And now, next thing we know is he doesn't get any money from the jury because he's a bad guy. Why? Because we allowed on this evidence about his crazy statement he made in his social media. That's the kind of thing we don't allow to happen, because it's not ascertaining the truth. It's simply making the jury emotionally react to hating one side or the other, or loving one side or the other, as the case may be, in a way that makes the ascertainment of truth no longer important. That's not what we want. And so when that negative consequence of unfair prejudice substantially outweighs the probative value, the judge is going to exclude the evidence. Also, danger of confusion of the issues is the next one. You can confuse the issues if, for instance, you had a reputation case where the defendant in a criminal case brings on the reputation that is so inconsistent with the crime. Let's say that it has a character trait for being nonviolent, and it's a violence case where someone violently reacted to someone for no good reason. Well, one of the things we'd like to perhaps prove up, and if the defendant tries to bring up his reputation for being nonviolent, we'd like to bring up previous actions of violence where the person actually did act violently. We want to bring up all their neighbors, about all the different times he's been screaming and ranting and raving at his neighbors and all this kind of stuff. Well, yeah, but the problem with that is that you have a danger that you're going to confuse the issues with the jury. The jury's going to say, is this about a violent crime that happened on a particular occasion, or are we trying all these different prior crimes that this person did, or bad acts these people did, this person did? Which is it? We're confused now. What are we trying here? Because we're hearing 12 cases of these neighbors coming up saying this guy acted violently, and you said the case is all about this one violent incident. So what's happening is you're confusing the issues with the jury, and so if that kind of danger or likelihood of danger substantially outweighs the probative value of the evidence, it's going to be excluded. Also, danger of misleading the jury. That's the same thing as I just talked about before, confusing the issues. If you do something that will mislead the jury into not determining the truth of the charge involved or the cause of action if it's a civil case, if you get them looking at some other issue and deciding the case on something other than what the law says the issue should be, then it's going to be a negative consequence. They're not going to be doing their job. And juries tend to do that, especially when you have the black hat, white hat kind of evidence. They will tend to give you all sorts of things like, let's see, I don't like that person, so I'm not going to give them a verdict. That's not consistent with the finding of truth. It's not something that we want to have happening in the case. So we will exclude it if it substantially outweighs the probative value. All right, undue consumption of time, we went over that also. Sometimes, if you have 30 or 40 witnesses, you're going to say the same thing that happened. You're probably not going to get all of them. You're going to get maybe 5 of them. Because the judge is going to say, after the 5th one, every one after that is not going to be very much value. It's going to take up a tremendous amount of time. And therefore, it's not a matter that I don't want you to have the evidence on. I just don't want you to have too much of it. You can overprove an issue. You can waste our time by doing that. If that's the case, and it substantially outweighs the probative value of what you're bringing in, then yes, then we're going to exclude it. Or if it's needless presentation of cumulative evidence, which is very similar to the undue consumption of time, or can be, because if you have cumulative evidence, that means lots of stuff. You have 30 witnesses to the same thing, you're going to get 5 of them maybe, you're not going to get 30. That would mean because you're unduly consuming time, and it's a needless presentation of cumulative evidence that you don't need to prove it more than once or twice, but 30 times is just too much. But undue consumption of time can also involve things, like where we're trying to prove up a bad act on the part of someone who brings up reputation evidence in order to refute the claim that they have a certain reputation. Because maybe they actually have bad acts they've done, and the reputation they have is not reflecting who they really are. That means we're going to have mini trials. We're going to have a whole bunch of mini trials about bad acts this person did, rather than dealing with the case at hand, and that can be an undue consumption of time. All right, so Rule 403, which is the exclusionary rule in California 352, are inapplicable when a party's testimony is impeached on a conviction for a felony offense to prove they lack credibility. So what that means is that if we have a felony offense and we're using it to attack the credibility of that person on the stand, then these don't really apply. And the reason for that is that if you have a felony offense, that's usually sufficient to indicate that you don't have a very good regard for the law because you decided to commit a felony offense, and you may not have such a great regard for the obligation to tell the truth under penalty of perjury. And so we usually do not apply these to that. Now, I will say that there's a caveat here. Rule 403 and California 352 can be used in connection with a felony offense if the offenses are so old and there's been no new offenses over many years, so that no longer can we say that those offenses really tell us who the person is now. Then we might be able to exclude it under 403 or 352 because of the fact that it's no longer very much probative value, and it can very likely mislead the jury as to who the person is now. You get somebody who in their teenage years was doing some burglaries because they were on drugs. They've not been on drugs for 40 or 50 years. They've led a morally blameless life since then, a model citizen, and really understood the error of their ways. That's not those kind of old convictions of felonies really probably aren't going to come in as evidence to attack the credibility, because they just don't tell us who the person is now, which is what we want to know. All right, let's look at some examples of unduly prejudicial evidence. If you look here at this link I've given you, there's an article on Mark Fuhrman and the Bloody Glove. Well, the problem with the Bloody Glove was not necessarily the fact that there was a bloody glove somewhere that Mark Fuhrman picked up and brought in eventually to the evidence locker at the police department. It was the fact that there were so many errors. I call them errors. They may not have been errors. If he was trying to actually convict somebody because of tampering with evidence, if that happened, then it wasn't a mistake. It wasn't an error. It was actually intentional. But whatever happened out there in terms of that bloody glove, there was so many mistakes in terms of how it was handled, and so much evidence out there of unaccounted for blood that was taken from O.J. Simpson that was within the possession of the police department itself and could have been taken by Mark Fuhrman and spread on this glove by Mark Fuhrman, that evidence could have been excluded on the basis of it was unduly prejudicial, because boy, there was no way to know whether that thing was actually the way it was when it was discovered, or whether it was created, either by mistake or intentionally. and therefore, and it was extremely damning evidence. If that bloody glove really was as it indicated it was, and that's because it had the blood of both O.J. Simpson and the two victims on it, was right where O.J. Simpson had recently been before he took off in an airplane after the murder, then it would be damning evidence. But if it turned out it was actually created, it'd be very damning evidence for a wrongful conviction. And so that one you ought to look at just to see how it's a good example of unduly prejudicial evidence, or potentially unduly prejudicial evidence. And so the court would have to weigh of course, the probative value of that evidence versus the chance that it might mislead the jury and or be unduly prejudicial for the reasons of convicting an innocent person. All right, so let's look at other examples of unduly prejudicial evidence. First is the collateral source payments in a personal injury suit. What those are is that very often in your personal injury lawsuits, you have been paid by your insurance company. For instance, you have your car totaled in the wreck. It wasn't you that created the accident, somebody else, but your insurance company will still pay for your car. And so the defendant will try to bring up, hey, the insurance company paid for his car, so don't ask me for that money, because since he's already been paid. Well, that's not how the law works. No, if somebody totals your car, they should pay for it, and it makes no difference that we were made whole by our insurance company, because now the insurance company is the one who should get the payment. It shouldn't mean that the defendant in the negligence suit should not have to pay, but that's what they try to do. That's unduly prejudicial evidence. That's the kind of thing where the jury will say, well, then why are we here? If this guy got paid by his insurance company, why don't we just go home? Instead of actually looking at whether this person was negligent and how many dollars in damages were assessed or should be assessed. Of course, there's other ones. Character attacks on a party. Sometimes we'll try to bring in, that a person had 2 or 3 DUIs or had, maybe a petty theft here or there, and try to prove that they're bad people. They're the black hats, and therefore you shouldn't do anything for them and go with my client because my client's the white hat, that kind of thing. Also, their resident status. Let's assume they're illegal aliens. Well, just because they're illegal aliens doesn't mean they weren't harmed, they weren't a victim of a crime, or that doesn't mean they don't have any rights to a civil court, because they do. It doesn't mean that we should be prejudiced against them because they're illegal. That they're still human beings, and they are entitled to being treated the same in the court as anyone else, and that is to ascertain what actually happened, apply the law to what happened, and come to a lawful result. And the lawful result doesn't depend on whether they're illegally here or not. Also, failure to file income tax returns. That's sometimes brought up by people who are trying to slime another person. Isn't it true, sir, that you haven't filed your income tax for the last 10 years? And of course, the jury's going to look back and say, oh my God, really? Well, I've had to pay my taxes. Why the hell aren't you paying your taxes? I don't like you. You're a bad person. You're a black hat, so I'm not gonna go for your side, no matter whether I should or not. That's sort of the kind of thing that you can see how that can be unduly prejudicial evidence. It doesn't have any or little, maybe a teeny tiny bit of probative value. It has a tremendous amount of unduly prejudicial effect. Alcohol or illegal drug consumption. Just because someone took illegal drugs at one point in their life, or even if they're doing it now, doesn't necessarily mean that they that means anything to the case in terms of we can have a breach of contract action, and the person paid some money for a particular item. That item never got delivered, and they're suing to get their money back. But now you bring up, oh, isn't it true that you take methamphetamine? Well, yeah, I do. So what? Well, you're a black hat, so the jury shouldn't go your way. That's sort of what this is all about. That's the kind of thing we don't want to see. It's sliming evidence. It's going to mislead the jury. It's going to make the jury decide on whether they have a black hat or a white hat, rather than on whether there was a breach of contract and whether money is due to the plaintiff or not. Dishonorable discharge from the military, exactly the same. Dishonorable discharges from the military may have absolutely nothing to do with anything relevant in the case, and it certainly is going to slime people, because when you're dishonorably discharged, it means you acted badly in some fashion. You didn't honorably get discharged from the military. You did something bad to get yourself discharged. And that, especially if you bring up the reason for that, it could be extremely bad in terms of sliming someone. Again, you have a breach of contract case. What does it matter that someone was dishonorably discharged from the military in terms of whether they are owed any money or not? Also, remarriage or wealth of the surviving spouse in the wrongful death case. So you have you have your spouse killed, and you want justice for the fact that they were wrongfully killed. And now what happens is they try to bring up, oh, isn't it true you got remarried to someone who's even wealthier than your previous deceased spouse, and so you're basically you're taken care of. So yeah, I guess we may have done something wrong, but you don't get any money for it. That's what the jury's going to think, and that's not what we want. We want the jury to decide whether it was a wrongful death. If it was a wrongful death, then what is the surviving spouse should get in terms of compensation for the death of that person, not whether she's okay now, and so therefore we shouldn't make any attempts to help her. It's all in terms. This is just misleading the jury into deciding the case on some criteria other than what the law requires, and so it's misleading the jury. And juries tend to be this way. They tend to see that kind of stuff as very, very important to the case because they're really looking at what they think of as justice. When people are entitled to legal rights, and taking them away from somebody is not really just, even though they don't see it that way very often. All right, let's look at some other ones. Evidence that will generate sympathy for a party is just as prejudicial as one that will generate prejudice against that party. So when we want to paint our client as the white hat, and of course, hopefully paint the other side as the black hat, we're going to try to bring up our client's poor financial condition, for instance. Here's not only do we want to paint the person who is our client who's in an accident, who's entitled to some compensation because the other person was negligent, but we want to show the jury how poorly. I mean, this guy has had to live in Skid Row because of this accident. You should help them out even more. You should double and triple the amount that you should normally give this person because of their poor financial condition. Well, that's not the kind of evidence we want. We want the person to be compensated for what they actually lost, not to elevate them out of a poor financial condition that was not the responsibility of the person who negligently hit them in the auto accident. Also, their poor health, another one. You see someone in poor health, you say, oh, I want to help them. You get sympathy for that person. You want to help them even more. You may, in fact, disregard all sorts of evidence as to whether they even have a claim at all, and give them something when they shouldn't have it, because under law, if the proper things were done, it would have been found, for instance, that they didn't have a claim at all. But no, because they have this poor health, we gotta help this person, so let's give them something. And that's the kind of thing we don't want to see. We want there to be ascertainment of truth under the law, and that's it. And if you mislead the jury into deciding the case on sympathy, then you're going to be basically making the justice system corrupt, because you're corrupting the jury, essentially. All right, not receiving a traffic ticket in an accident. Now, this is an interesting one. We expect that if you ran a stop sign and you hit a car and there's a major accident, lots of people are hurt, maybe killed even, that there would be a traffic ticket given to that person. And the fact that there wasn't will be brought up by the defense as if that means the person didn't do anything wrong. It confuses the jury. Wait a minute. If this person really ran the stop sign, why didn't he get a ticket? Well, many times when you're in the middle of one of those disastrous situations, the last thing the cops are worried about is giving this person a ticket. They're not even going to arrest them. They're going to try to get these people to a hospital, and they're trying to get traffic, adjusted around the accident. They're trying to get the whole thing cleaned up, and they're doing lots of things there. The last thing they're going to worry about is a traffic ticket. So it has really no value in terms of actually meaning anything. But they'll bring it up as a way to try to confuse the jury. It's a good example of one that, if you think about what the jury is going to do with that, it's just not good. And it has very little probative value, if any, but it'll have a tremendous prejudicial effect. All right, lack of prior accidents in a personal injury case. So what happens is you get this, little old lady who, just unfortunately is negligent in her driving and slams into somebody. They're going to say, well, I've had 60 years of driving and I've never had an accident. The jury's they're going to think, wow, that's going to generate some sympathy for this person. Boy, the first one, man, you did a good job on the first one, but boy, you know what? We're gonna have to give you something on this because we feel really sympathetic for you. You're not like you're a bad driver, You're somebody that we should feel sympathy for, and we'll adjust anything based on sympathy. No, we do not make judgments based on sympathy. We make judgments based on the facts, the law, the truth of what happened, and that's it. So once you get sympathy in there or prejudice into there, you've taken the jury outside of what we want them to do. All right, defendant's statements of threats to an arresting officer were found to be unduly prejudicial. You should look at this case. It's a very interesting case. The link is here. So when you get the PowerPoint, just take this link and look at it. It was a very interesting one. It turned out that normally speaking, when someone threatens an arresting officer, it's usually pretty good evidence of what we call consciousness of guilt. No one who is innocent, for instance, would typically threaten the arresting officer, but people who are guilty might do that to try to get the officer to back off and not arrest them. But in this case, it was found that they were unduly prejudicial. So it's an interesting case. It's one that you should look at. It'd be a good one to see exactly how this all works. All right, there's also one where defendant granted a mistrial for overly prejudicial testimony of an investigating officer. Another very good example of how we can, unfortunately, introduce our own overly prejudicial evidence and get ourselves into a situation where we get a mistrial because of it. So we've got to be very careful that when we want to bring in the sliming evidence, we better make real sure that it has at least an equal amount of probative value so that we will be allowed to bring it in and it'll be upheld on appeal as well. All right, that's it for the Rule 403 and Rule 401, which are two fundamental aspects of evidence law. One is what kind of evidence will be admitted, which is all relevant evidence will be admitted unless there's some law or rule of evidence that excludes it. And then we looked at, of course, the Rule 403, California Rule 352, that will allow us to exclude relevant evidence when there are certain negative consequences that can happen at a trial. All right, again, if you have any questions, please feel free to give me a call.